Welcome to the Only Male Cruise Show, the podcast. I am the only male cruise. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work. All right. Welcome to the Only Male Cruise Show, the podcast. I am the only male cruise. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Shout out to Baby Shay. Thanks for pulling up. Appreciate you being one of those number one mods, baby. And shout out to everybody that pulled up. So, yeah, the hits just keep on coming, so it seems. But this is just an indication for us to, for R. Kelly supporters not to, don't get weak now, don't give up the fight now. And I guess if you choose to, I guess you can. It's your prerogative. But, the trial is still going on, or his legal battles are still going on. So, last month in May, Bongine had submitted a motion, and this is the video. So you can find it on the playlist where I go through the whole motion that Bongine submitted. The judge today made a decision on this particular motion. We're going to go over that. And the judge also made a couple comments about June Brown's motion. So the details of that motion are this video here on my channel. So you get a chance, check those out for the whole details of the motion. But, I'm not going to keep you long. I just want to get in here and keep y'all in the loop. I hope everybody's doing well behind the sentencing from yesterday. Kelz got 30 years. And I'm seeing a lot of memes and a lot of social media comments really just dogging Kelz out. And I just hope that the supporters are not feeling low or feeling like giving up. I doubt it, but just in case you are, encourage yourself, because round 2 is coming through. So we got to be ready for it. All right, so let's just get into this motion. So on the 28th, Bongine submitted a motion in limine. And basically she's saying, that the government filed a 13-count superseding indictment, charging Kelz with child pornography, conspiracy to obstruct, 3 counts related to receiving child pornography, enticement counts, things of that nature. So the counts in the state of Illinois are just a little bit different than, not too much, but a little bit different than what was charged in New York. So starting with, the court should preclude the government from introducing uncharged other bad act evidence. So Bongine is saying that the government has produced voluminous discovery in this case, reflecting allegations by scores of women who have alleged that defendant mistreated them in some form or fashion over the past 30 years. Many of the allegations are unsupported by corroborative evidence. This court must prevent defendant's trial from being engulfed by irrelevant and excessive bad character evidence that adds little to the jury's assessment of whether defendant committed the charged offenses. Defendant cannot be expected to defend against dozens of uncharged claims of abusive and sexual misbehavior, particularly where defendant must already defend against charges of sexual abuse by 5 different women, decades after the conduct allegedly occurred. So unless this court severs counts 10 through 13 of the indictment from the remaining counts, the jury will hear extensive evidence related to the defendant's alleged sexual conduct toward minor 1 and 4 other minors. As argued in his motion to sever, defendant contends that joinder of the counts pertaining to minor 1 with the enticement counts related to minors 3 through 6 is unduly prejudicial to the defendant, particularly where the evidence related to minor 3 through 6 is significantly weaker than the evidence related to minor 1. So pretty much, if the judge doesn't break that down, then the jury and everybody else can interpret that the most severe behavior as alleged towards minor 1 can be applied or imputed or thought to be the same level that was applied to minors 3 through 6. So that's pretty much what she's saying there. If this court disagrees and orders that all counts be tried simultaneously, the government begins with a distinct advantage where it will argue a pattern of conduct based entirely on charged conduct. In light of these circumstances, the government has no need for additional uncharged bad act evidence. So if you're gonna lump all these, all of the charges from minor 1 through minor 6 and not make that differentiation between the extent of abuse or behavior alleged, where it was more significant with minor 1 as opposed to the other minors, if you're just going to lump it all in, then Bongine is saying, then don't put any of this, don't allow the government to use uncharged bad act evidence. For example, don't let Lewis come in here. Lewis is not part of this case, to my understanding. So don't let that in. We don't want to hear all that. The legal standard. Bongine says that generally evidence of other acts is inadmissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with character. There is, however, an exception to that general rule where the evidence is admitted to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. She goes on further to cite some court cases. But y'all, I don't like to go through all that because it gets a little confusing. So she goes on to say, in other words, the rule allows the use of other act evidence only when its admission is supported by some propensity-free chain of reasoning. So other bad act evidence would be supported if it alludes to whatever else he's being charged with, essentially. Even if other act evidence is relevant without relying on a propensity inference, it may be excluded under Rule 403, which applies with full force. In this context, and gives the district court discretion to exclude evidence if it is probative value, if it substantially outweighs the danger of unfair prejudice. In the case at bar, the government has not provided notice concerning whether it will attempt to introduce testimony or other evidence of uncharged allegations of misconduct by other women. Notwithstanding, defendant moves to bar evidence of the following and further requests that the government immediately identify any uncharged bad act evidence it intends to present at trial. So as of the 28th, Bongine still doesn't know if the government is going to, present, if they're going to bring our line back or anybody else. So she's saying here, hey, you need to tell the government to let us know right now. Defendant moves to bar the following other bad act evidence related to defendant's marriage and alleged sexual relationship with Aaliyah. Defendant is not charged with any conduct related to his relationship with Aaliyah, who is deceased, including evidence that defendant married Aaliyah in 1994 when she was underage. Introduction of such evidence serves no legitimate, non-propensity purpose. Furthermore, any probative value of such evidence is substantially outweighed by its prejudicial effect. Accordingly, defendant moves to preclude testimony of any evidence related to his purported relationship and or marriage to Aaliyah. Now let me get in these comments real quick. I do again want to thank y'all for pulling up. Be sure to hit the like button, share, subscribe if you haven't already. Replay gang, leave a comment. I want to hear from you. Shout out, of course, to Baby Shay, Trina16, Tiffany Only Please, and Ernestine Lee. Hey, y'all. Shout out to Tanika and McKay. Another beautiful mod sister. Appreciate you so much, y'all. Loving life. What you talking about, girl? Saying hello. The only male Cruz. Being honest, I'm not giving up, but I am completely blown over the number of years he was sentenced. I hate that he has to be a sitting duck for who knows how long. Sad. Yeah, I get you. I get you. And I was sharing with somebody yesterday that Kelz would probably right now just be just wholly depressed if he had been out on bail all this time and then went to court yesterday and they remanded him. You know what I mean? That would have been one hell of a shock. So, I mean, we can at least be comfortable to some extent to know that, when Kelz went back to his cell yesterday, at least he's accustomed to that right now at this point. So that's not an emotional battle that he's got to deal with. I'm sure he's down, but he doesn't have to deal with, that shock value of being remanded. So, but we got to stay strong for him, y'all. Okay, so Bongine also saying uncharged allegations of women who claim that defendant abused or mistreated them. The voluminous discovery in this case reveals that scores of women have accused defendant of engaging in varying forms of mistreatment toward them. The government has not provided notice of any intent to offer such additional evidence. Defendant moves to bar any additional uncharged allegations of misconduct. If the government intends to introduce uncharged other act evidence, defendant requests that the government immediately disclose what evidence it is that they seek to introduce and for what purpose. Okay, evidence that defendant impregnated any accusers and or facilitated their abortions. The discovery records reflect that at least 2 individuals purportedly were impregnated by the defendant or possibly impregnated by the defendant, and that the defendant facilitated their abortions. The statement by these accusers are imprecise, and there is no corroboration that these claims are true. Regardless, such evidence serves no legitimate evidentiary purpose and would be offered for no other purpose than to breed contempt for the defendant. Should the government intend to offer such evidence, defendant moves to bar it. Evidence that defendant infected any sexual partners with herpes. Several accusers, including minor one, allege that defendant infected her with a sexually transmitted disease, namely herpes. Again, this evidence serves no legitimate non-propensity purpose and would be offered solely to inflame the passions of the jury. Defendant contends that such evidence should be barred as having no relevant purpose, or in the alternative, the probative value of such evidence is substantially outweighed by its prejudicial effect. Evidence that defendant was previously sued by accusers and or settled lawsuits brought by those accusers. The discovery record contains significant evidence that defendant has been previously sued by numerous women for a range of behavior. The lawsuits resulted in settlement agreements negotiated largely by co-defendant Durrell. Defendant concedes that it is possible that Durrell's role in negotiating settlement agreements on his behalf could constitute relevant evidence in this case. That said, the introduction of evidence that defendant was sued and the cases were settled should be barred to the extent it is introduced solely to show his bad character. All right, Bongine says, video recordings of sexual acts that do not involve the charged conduct. The government has disclosed other video recordings of sexual acts between defendant and other women that do not appear to relate to the charged conduct. Now, why would they? We hope the government ain't going to bring in some tapes that have nothing to do with the case. The government has not disclosed whether it intends to disclose or whether it intends to offer those video recording sex acts for some other purpose. Defendant moves to bar any explicit video recordings. All right, prior conviction of defendant. Defendant was convicted on 1 count of RICO Mann Act violations and inducement offenses in the Eastern District of New York. Defendant moves to preclude the government from introducing evidence of his prior convictions. Separately, defendant joins defendant Brown's motions in limine as to arguments 2 through 5. For the foregoing reasons, defendant seeks an order from this court granting defendant's motion in limine. Now, that is really key, and that's very interesting because if y'all know, when we talked about when June Brown submitted his motion, he was like, don't allow the government to ask these questions, blah, 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 blah. So she's talking about arguments 2 through 5. Let me pull this up real quick. And also, let me see here. Let's see, Lovable Leo, good evening to you as well. And Loving Life said, I agree with you. Y'all be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. So let's take a quick look at June Brown's motion. We're not going to go into it in detail. And like I said, on this video here, that's where we're going over his entire motion. So y'all can definitely check that out. But what Bongine has just said, where Kelz and them, all right, defendant joins defendant Brown's motion as to arguments 2 through 5. So just real quick, arguments 2 through 5 that June Brown made were this court should preclude the government from eliciting testimony regarding certain other crimes, wrongs, and acts by Mr. Brown. This court should bar the government from eliciting testimony from minors 4 through 6 regarding the times that Brown booked hotel rooms and otherwise made travel arrangements. That's argument 2. Argument 3 is, let me see here, scrolling down, yeah. Argument 3, damn, argument 2 is one hell of an argument. Argument 3, this court should bar the government from eliciting expert testimony from unqualified witnesses. Okay. And argument 4, this court should preclude government witnesses from providing summaries or statements from interviewed witnesses for non-testifying individuals. And argument 5 is, this court should preclude the government from making golden rule arguments with regard to the jury and the defendants. And if you remember, that golden rule is put yourself in the defendant's shoes. How would you feel? How would they, if you were him, blah, blah, blah. So Bongine is in agreement. Kelz and them are in agreement with Brown's argument on that as well. So now the judge, y'all. I'm going to give this judge a little bit of credit, only because, I don't know, I get a different vibe from the way his response to the denial of the motion is, okay? Because he certainly denied Bongine's initial motion. So the one I just read to you was recently submitted. He hasn't ruled on that. But this ruling, he is, on this ruling, it's the one that Bongine submitted in May. So the judge is saying here, on February 13th, the government filed a superseding indictment charging Kelz with 13 counts. Defendant Durrell previously moved to dismiss count 5. Okay. This is really locking in. This judge's decision is really locking in why Durrell and them don't want the severance. Okay, so this court denied the motion that Durrell had previously submitted asking for severance. Okay. And actually, it says this court denied the motion. Defendants filed another motion to dismiss, arguing that all counts except count 5 should be dismissed. Durrell is really trying to get off light. He wants all the counts he's indicted on to be dismissed, and then he doesn't want to sever count 5 so he can get on the stand and blame Kelz. And then when the jury renders their verdict, they'll have mercy on him because then Durrell will look like he made me do it. Okay. All right. So counts 1 through 4. Here's what the judge is saying. Counts 1 through 4 of the indictment charge defendant Kelly with producing 4 videos of a minor engaged in sexually explicit conduct. The indictment states that there that the videos were produced between 98 and 99. At the time of the charged conduct, the statute of limitations expired once the minor reached the age of 25. Kelly argues that as a result, these charges are time barred. In response, the government argues that the limitations period was extended when the statute was amended and the extended date should apply. Now, the rule is 18 U.S.C. blah, blah, blah. That's the rule that is governing the statute of limitations. So the judge is saying that this rule was amended in 2003, extending the statute of limitations to the life of the minor. The statute was amended again in 2006, extending the statute of limitations to the life of the child or 10 years after the offense, whichever is longer. If the operative limitations period is the one set out in 94 version of the statute, then counts 1 through 4 expired in 2009. If the amended statute of limitations applies, the counts are timely brought. Now, he goes on to talk about the Supreme Court has this two-step test to decide, whether a federal statute applies to past conduct. I ain't gonna go there with y'all because it's too deep. It's too much. But he does mention, what's her name? Ghislaine Maxwell. He says that the final version of this bill, because the final version, when they last changed this statute of limitations, or the whole federal aspect of it, the final version of the bill omitted the thing about this changing the bill and it being retroactive. So if they change the law, can they go ahead and scoop up things that happened prior to the law changing? And the judge is saying, well, the bill being retroactive was not addressed for the most part. He's saying the final version of the bill omitted this provision, and Senator Leahy confirmed that the omission was intentional. Senator Leahy, Amber legislation, blah, blah, blah. Judge Nathan of the Southern District of New York recently dealt with this precise issue in the prosecution of defendant Ghislaine Maxwell. There, the judge analyzed this rule, finding that Congress not only permitted but intended this rule to allow prosecutions for past conduct for which the statute of limitations has not expired. With each amendment to this rule, the statute of limitations increased in light of the lack of retroactivity provision. So with the law not saying it doesn't apply, or really no clarity on it, but steadily increasing the statute of limitations, the court finds that the statute does not prescribe its proper reach. That's a little bit confusing for me, especially in the end, for his reason for denying it. But it says here, the court next moves to the second step of this test. Basically, he's saying that in the Seventh Circuit, applying procedural statutes which effectively enlarge the limitations period does not violate this ex post facto clause, so long as the statute is passed before the given prosecution is barred. Let's see here. Occurring to the current blah, blah, blah. The court will not disturb well-settled law to create new statutory rights where none currently exist. Counts 1 through 4 are timely. So he's made his mind up there. Count 6 charges all defendants with conspiring to receive child pornography. The indictment states that the conspiracy took place between 2001 and 2007. Count 7 charges defendant Kelly and Durrell with receiving 2 videos of child pornography in violation of the statute of limitation law. The indictment alleges that Kelz and Durrell received these videos in August 2001. Count 8 charges the defendants Kelz and Durrell with receiving 1 video of child pornography. The indictment states that Kelz and Durrell received this video in April of 2007. Defendants argue that counts 6 through 8 are subject to the general 5-year statute of limitations and are now untimely. The judge is saying that with this rule, the government argues that the court should apply the statute of limitations, but according to the rule, there is no statute of limitations for an offense under Chapter 110 of Title 18 of the United States Code. So these looks like count 6 through 8 are coming under a whole different code, which is why they ain't got to deal with the statute of limitations on that. Count 6 through 8 all charge defendants with violations which fall under Chapter 110. And as such, this particular law applies to count 6 through 8, and that became effective July 27, 2006. The court finds that counts 6 through 8 are timely. First, count 6 and 8 of the indictment both state that conduct in question concluded after the statute of limitations law was enacted. Therefore, the statute of limitation clearly applies, and a prosecution for these counts can be brought at any time. And that's because, remember, the statute of limitation laws expanded, and now they're either the lifetime of the individual or 10 years after the act, whichever one is longer. Okay? So that's a trick bag in and of itself. The accused conduct in count 7 took place before this law was enacted. The court applies this particular test. In the first step, the court says, I'm going to skip that part, says the court finds that applying the statute would not impair the defendant's right. The parties dispute what statute of limitation applied to count 7 during the time of the accused conduct. The defendants argue that count 7 is subject to the general 5-year statute of limitations. The government argues that the limitation period extended until relevant minors turned 25. The court notes that the dispute is largely irrelevant. Either way, count 7 is timely. Applying the shorter limitation period of 5 years, the statute of limitations would have expired in August 2006. But since this other law was enacted before the original limitation period expired, there is no ex post facto problem, meaning defendants' rights are not infringed. Okay, so according to him, count 7 is timely. Counts 9 through 13 in the indictment charge defendant Kelly with knowingly enticing minors to engage in sexual activity and the blah, blah, blahs. We're hip to that, y'all. The indictment states that the activity occurred between 1996 and 2001. Like with charges 1 through 4, the same statute of limitation law provides the relevant statute of limitations. At the time of the accused conduct, the limitation period expired when the minor turned 25 years old. The earliest date at which any minor in the accused conduct turned 25 was August 2005. As discussed earlier, this rule was amended in 2003, extending the limitation period to the life of the child. Earlier in this order, the court analyzed the amended version. Let me skip through a lot of this legalese. Defendant Kelly's rights are not infringed because of this particular statute of limitations law. And simply because it was twice amended before the previous limitation periods for count 9 through 13 expired, the court applies the current version of this rule to counts 9 through 13. Counts 9 through 13 are timely as well. In sum, defendant's motion to dismiss is denied in its entirety. Okay, Judge, in its entirety. All right. Motion to sever. All right, so defendant Kelly has also filed a motion to sever. Kelly requests that the motion, Kelly requests that defendant Durrell be tried separately and that counts 10 through 13 be severed from the rest of the indictment. The judge is saying that Federal Rule of Criminal Prosecution 14 authorizes district courts to order separate trials of counts, sever defendants' trials, or provide any other relief that justice requires. District courts have discretion to grant the relief they deem proper, whether it is severance or something less drastic, such as limiting instructions. In cases involving conflict defenses, severance is not required, even if prejudice to a defendant is shown. A court must only grant severance if there is a serious risk that a joint trial would compromise a specific trial right. One of the defendants, let me read that over again. A court must only grant severance if there is a serious risk that a joint trial would compromise a specific trial right of one of the defendants or prevent the jury from making a reliable judgment about guilt or innocence. Severing defendant Durrell. Defendant Kelly argues that Durrell should be tried separately because of antagonistic defenses and because one of Durrell's lawyers may have a potential conflict of interest. In the motion to sever, Kelly alleges that both he and Durrell may present evidence against the other. Kelz argues that he intends to present evidence that Durrell controlled the purse of the operation and pushed Kelly to continue to work to keep the money flowing. Kelz also argues that Durrell might be used as a witness against him. Kelz's allegations do not provide further detail. Kelz argues that severance is required because he intends to show that McDavid had an interest in Kelz continuing to work. However, as the government points out, this evidence is not necessarily antagonistic to or even inconsistent with Durrell's possible defense. It is entirely possible that Durrell pushed Kelz to continue working and also conspired with Kelz to conceal his misconduct. As presented, Kelz's motion reads as blame shifting. Blame shifting among co-defendants does not mandate severance. That's some language right there. Moreover, Kelz does not specify exactly what evidence he expects to present that will compromise any of Durrell's trial rights, nor does he specify what evidence he expects Durrell to present that will be used against him. The motion does not raise any serious risks of impeding defendants' trial rights or that a jury would be prevented from making a reliable judgment. So I'm going to tell y'all right now, Bongine is going to be doing a whole lot of objecting when they get to in the courtroom, when they get to talking about this count 5, because the judge is saying Kelz didn't lay out exactly what it is that Durrell might present that's going to, make it difficult for Kelz. And Durrell didn't lay out what they're going to say to make it difficult for Kelz. So that is going to be battled out on the courtroom floor. Because, again, in that other video, that's what Durrell's attorney said in his motion, that, you're making all these accusations, but you ain't saying what you mean. Say what you mean, Bongine. And Bongine is like, I'm not going to lay all my cards out on the table, just like y'all didn't. All right. But when they get in that courtroom, everything's going to be presented. All right. Kelly next argues that Durrell's lawyer, Vadim Glosman, may have a conflict of interest. Kelz retained a lawyer named Ed Jensen to represent him in a criminal case resulting in Kelz's acquittal in 2008. Between 2008 and 2018, Kelz frequently consulted with Jensen. Kelz argues that through this connection, Glosman may have privileged information that could be used to Kelly's detriment. Glosman denies that he has any privileged information about Kelly. Glosman stated that his only conversation with Kelz and the first time he met Kelz was at Kelz's indictment hearing for this case. Kelz does not identify any privileged information or any class of privileged information that he alleges Glosman accessed. Kelz submitted a declaration on his own behalf where he states that he does not have a specific memory of ever consulting with Glosman. All Kelly offers is that he has a distinct memory of Glosman's name as someone who worked with Jensen. Kelly has not presented sufficient information to show that Glosman has an actual conflict of interest. The court will not sever Durrell and Kelz trials. This comes from the judge, y'all. This is his decision. Counts 10 through 13. Kelz argues that counts 10 through 13 should be severed from the rest of the indictment because he will suffer substantial prejudice otherwise. Severance may be warranted if a defendant is improperly coerced into testifying about a count on which he wishes to remain silent. When a defendant seeks to sever charges because he wants to testify to some charges but not others, he must show that he has a strong need to testify on one count but not the other. Kelz alleges that the evidence in support of counts 1 through 3 is stronger than the evidence in support of counts 10 through 13. In support of his argument, Kelz states that counts 1 through 3 are supported by video evidence, while counts 10 through 13 are supported by testimonial evidence. Kelz argues that he has important testimony to give concerning counts 10 through 13 and a need to refrain from testifying as to counts 1 through 3. Now, I just said something right here. Y'all know if y'all was in church, the pastor would say, I just missed your chance to shout. What? Let me read this part again real quick. Kelz argues that he has important testimony to give concerning counts 10 through 13 and a need to refrain from testifying as to counts 1 through 3. What do y'all think about that? I mean, what are y'all thoughts about that? Let me take a minute, shout y'all out. Tiffany Only, Ernestine Lee, thank y'all for pulling up. Y'all appreciate y'all. Be sure to hit the like button, share, subscribe if you haven't already. Replay gang, you know what time it is. Leave a comment. You know I want to hear from you. Let me see. I'm just scrolling through the comments real quick. Trina16 said, yes, I just went over my head. Wait, uh-oh. I hope Kelz don't, ain't that it, girl? But see, I think he's mentally in a space because he's already, these are my loves. What's happening, Mad Pill? I'm just going to presume that everybody in here knows who Mad Pill is, and everybody in here is subscribed to Mad Pill with the bell, the notification bell, so that when they come on, y'all subscribe to this team right here. Boy, they know how to light up a Friday night. They are Kelz advocates. How y'all doing, Mad Pill? Thanks for pulling up. Y'all know I love y'all. But yeah, Taniqua, I feel like we don't really have to worry about that because, if Kelz had just got locked down on yesterday, then yeah, maybe so. But because he's already been there, he probably went to a cell with his head low, but I'm sure that he was, I think he's going to be all right, and especially because I feel like, with Bongine being right there in New York, the opportunity to meet with his counsel on a more frequent and regular basis is also going to be, uplifting for him as well. Let me see something here real quick. Yeah. All right. So let me get back up in here, but I wonder what this important testimony to give concerning counts 10 through 13. I'd like to know what that is. All right. So hold on just a minute here. All right. Kelz's motion to sever does not specify exactly how he will be prejudiced if all the counts are tried together. Kelz does not adequately explain his assertion that the evidence in support of counts 1 through 3 is stronger than the evidence in support of counts 10 through 13. Kelz claims that the video evidence is much stronger than testimonial evidence of questionable veracity, but fails to provide more detail. Further, Kelz's motion fails to present evidence showing why he has a need to testify on only some of the counts. Kelz's motion asserts that severance is warranted, but does not provide specific evidence in support of that assertion. For that reason, the court denies Kelz's motion to sever. Okay. In conclusion, for the results stated herein, defendant's motion to dismiss these counts and Kelz's motion to sever are denied. So they're going to have to put it on the floor in the courtroom. And so I would not be surprised if in the court that Bongine is going to bring this up again. because by that time you've got your, let me see if I can find it, remember that term. You know how you have by that time, if whatever evidence you're going to submit will have already been needed to been submitted. And Bonjean will have, discovery. She'll have a way better idea of what the government expects to submit. So when she brings it up in the court, she'll be able to say, based on this, based on that, because the government's going to know what Kelz and them are bringing, and Kelz and them are going to know what the government's bringing. So we're going to see this argument again. And the judge, Darrell and them's attorney may, Your Honor, you already ruled on that. We object. And the judge might shut it down, or he might entertain conversation. So if we can expect that. That is going to happen. Let me see. Oh, wait, hold on. Love and Life said, when making up laws and rules along the way becomes a thing. Yeah. And I said yesterday in the video that I made a mistake, because I thought I understood that Governor Pritzker of Illinois had changed some statute of limitations. I read that. I called myself having read that. But based on this judge's argument, he pretty much made it clear. And you know what? Kelz does have an Illinois state case, so that might be the other argument. But either way, when I was speaking yesterday talking about the statute of limitations, I was referring to this case coming up, and so that doesn't even apply as far as the erroneous statement I made yesterday. So I just want to put that out there. Shout out to Pink Ice. Thanks, girl, for pulling up. Y'all know I appreciate y'all. That's right. Mad Pill. Mad salute to you. Let's see. K baby, what's tea, baby? Thank y'all for pulling up. Y'all make sure you hit that like button, share, subscribe if you haven't already. And just like with Mad Pill and them, hit that bell, y'all. So that's where we are with these motions. And I don't know. Do y'all think it seems fair? Does this judge seem like he's coming out the gate? I'm going to give the judge credit for saying you didn't provide enough evidence. I would feel better that any motion that Bonjean submits, I'm going to feel better if the judge grants her motions, because then I'm going to be thinking, okay, well, the judge is seeing exactly what Bonjean is talking about. So under those circumstances, then, but when he denies any motions that Bonjean makes, then it, makes me think like, damn, But do y'all feel a sense of biasness just from the way this motion reads? How do y'all feel about that? What are y'all thoughts? And then I'm also wondering when this judge will respond to when he'll respond to. Hold on, just a moment, y'all. This motion in limine. The deal about the uncharged bad evidence. When is the judge going to respond to that? Will it be quick? Because it took him a minute or two. So clearly, the judge had to do some homework to cite the right laws and make sure he was understanding what was up. So that's pretty much where we're at with these motions right now. And we just have to see what's going to happen. We do know that Bonjean is saying if the government intends to bring any bad act evidence, if they're going to bring that, then they need to let her know immediately. The judge needs to tell them, bring it immediately. Bonjean is also saying that, the government should not be able to even bring nothing up that has to do with Aaliyah. He's not even charged with anything related to Aaliyah. So why bring in that bad act evidence? And if they, judge, if you're going to allow them to do it, or if that's their intention to do it, you need to make them tell us now so we can prepare for that. So I don't know. It's definitely organized motions, definitely organized responses. I ain't mad about it. I don't know. Checking these comments to see what y'all think about it. Let me see here. Tiffany only, I'm giving every judge, oh, girl, I'm giving every judge a side eye until you show me something different. Fairness and equality. Ain't that the truth? Yeah, they don't get from now on. The legal system does not get the benefit of the doubt for me. Y'all gonna have to really, really, really prove that these people are deserving of the charges that y'all got them jammed up for. Loving Life said, right now, it feels like a repeat of yesterday. I'm really side eyeing all judges at the moment. That's true. I feel like the judges are working against Kelz. All of this is so sad. Kelz doesn't deserve this stuff, and I agree with all that. And, Tiffany, a lot of people are probably feeling like you're feeling right now, you know, and it's okay. We just can't feel this way for long because we got to get in here and fight about it. We got to argue about it. We got to keep the awareness of it because, I don't even know if Mad Pill and them are still in the house, but, I was on one of their panels a couple months ago, and I didn't know until I was on their panel that they weren't Kelz supporters at the beginning. They weren't supporting Kelz. They thought Kelz and them was guilty. But it took people like Infamous Sylvia and everybody else, DJ Tyson and them, everybody, that is, showing the inconsistencies and demonstrating the fact that we really can't take the government on face value. Just because the government accused the people of it does not mean they're guilty. And I was in the same boat. So we got to continue to speak out about, about the one-sidedness. So that's why I'm sitting up here now doing content on R. Kelly, because I thought he was guilty in my book until I, became hip to the transcripts. Feel the Glow said, did you guys see what Lil Boozy posted about Azriel? Feel the Glow? What did he post? And now you got to type something now, baby, or send that link to one of my mods so they can, so that that way they can post the link in the chat. But what's tea, baby? Let's see. Yep, free Kelz. So, and speaking of the government, let me check this. Give yourself some credit. Also, you are on this side now, putting out information. Yeah, that's true, and only because some real people who, in my opinion, were not and are not clout chasers, were just bringing the facts, drop it in tea, and again, it's hard to conceive that the government would have allowed the evidence that they did that convicted Kelz, but we see that they did. And we see that the judges don't have a problem. They didn't have a problem with it. So, but that leads me to what I was getting ready to say, which is about the YouTuber that had been arrested. Now, when I did that video on Dubowski, I got to thinking about that earlier today because, I was checking for updates. And as an update, there is a telephonic hearing for him on tomorrow. So, his situation is moving right along. But when I was live doing that video covering that topic, there was at least one or two people in here that were subscribers of his. And they were like, he didn't mean that. He was talking about protesting. He didn't mean that. What he's charged with, that's not what he meant. And, so I got to thinking, I'm like, why wouldn't the government just like send a letter or send an investigator over there and say, hey, what's up with this? And give him an opportunity to, explain himself. Why y'all got to go from 0 to 100 real quick? I don't get that. I don't get that. And now y'all got this man, in a predicament now where he's got to go through all these changes. If he's remanded, which to my understanding he is, if he had a job, is the job give him time off? I mean, just one thing can just ruin someone's life. And y'all could have just sent an investigator out and asked him. But according to the shooting in Buffalo, New York, there was a federal agent allegedly inside the chat an hour before this supremacist went out and laid them people out. And y'all didn't go, y'all ain't pull him. So, the disparity in the way things are charged is just, it's too much. So you're right, Tiffany. Only please, we can't take the government at face value when it comes to these laws. K Baby said, I think Kelz is going to be okay, though. He just has to go through to get through. But there has to be a light at the end of all this. Indeed and amen. Phil the Glow said, check out his Twitter page. He posted a page of the transcripts where her parents and Azriel have been exposed for their dirty work. Let me see. Looks like he's aware of the setup too. I'm sure he watches pro R. Kelly channels too, who exposed the setup. I'm telling you, people are starting to wake up. Let me see. So I must have missed a comment somewhere. Oh, okay. So check it. Okay. All right. Okay. Let me see. Thanks for that update. Feel the Globe. Definitely going to take a look at that. Let me see. Tiffany only. I also noticed that Mel and only one other person has spoken today. I'm going to give others the benefit of the doubt that they are pissed the hell off and in shock and need that moment. Yeah, that's true, Tiffany. I think that's the case too. Because if y'all want to know the truth about it, I was going to come on early this morning. I was going to wake y'all up. I was going to be like, who up? Because and see, I feel like I have a little more optimism right now because, I didn't, I wasn't on this from day one. I've had my moments where this Kelz thing does seem overwhelming and, it seemed like it ain't no light at the end of the tunnel. So I can imagine how, the OGs in the Kelz coverage, I can imagine how they feel. So I'm glad that I ain't been in the game that long, that I have some, enthusiasm and I'm still optimistic because, in a couple 4 or 5 months, hell, I might need the OGs to encourage me and uplift me and say something positive. So, but you're right, Tiff. I noticed that too. And we're going to keep all of them in prayer and hoping the best for them, that they'll feel better about it and they'll come back, refreshed and rejuvenated and stronger, because they've made a lot of impact. And so it takes all of us, y'all. Said they've been watching him for a while. They have him on video talking about how he will blow stuff up. And he even said himself, okay, K baby, I'm a roll with you on that one, girl. I'm gonna rock with you if that's what you said. But see, and that's what I'm saying. The first time I ever watched Dubowski's channel was when that news had broke. So under those circumstances, I really wasn't hip to him. But I don't know. I don't know. The government, I think they could at least send an investigator around, I guess. But I ain't up. I would have went live, but I just can't even talk about it really without shedding tears. So I really cannot even stomach it. Yeah, I hear you. I hear you, K baby. I feel you, sweetheart. And steady while we're down and feeling sorry for Kelz, feeling bad about this turnout. Chicago is still moving right along. And like I said, find the positives. The positives are that Bongine is still on the case. The positives are that Bongine is probably 5-10 minutes away from Kelz right now while he's still in New York, which means that's going to be a better, because in some motions, Bongine, matter of fact, in one of the motions for Illinois, or even the New York, which she was trying to get the sentencing delayed, she said, look, I'm busy. I'm stationed out in New York, but I'm in Cali and blah, 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 blah. So now it's more together. And Bongine is a powerhouse. So this is only just going to be beneficial. So we got to keep our heads up, y'all. We have to. If nothing for Kelz, because if Kelz has an opportunity to look at YouTube, I don't know what their social media access is, but to be honest with you, shit, Kelz probably is like, damn, ain't nobody talking about me. Y'all, where the love? So all right, let me get off of that soapbox. I'm sorry, y'all. Feel the Glow said, under the post, the Shade Room on Instagram, people are blasting her for the post. Look at the comment section. They are blasting. Ooh, yeah, we're going to check that out. Let me see. Let me see. I agree. Let me see here. Feel the Glow came here and dropped some tea. Just saying. JS. Is still posting about Kelz and clapping back at all negativity. Love and Life, tell me who JS is. I'm not sure if I know who that is. I know I gave him some money on those royalties today. Started early this morning, but I'll be damned if I play a feature track with that didn't help him. I know that's right. And you know what? After yesterday's conversation, I also was thinking maybe we need to put a social media campaign out on those very artists because they steady dropping. We know Uncle Charlie, he's been doing some concerts recently. So maybe we need to start speaking up about that. And we ain't got to even launch an attack. It's just like, okay, if we see him out there, hey bro, why didn't you ain't got no words for Kelz? Okay, let me see. Love and Life, you talking about, okay, Jocelyn Savage. Thank you, sweetheart. I feel you. Go to the page email so we can all comment here. Let me see. Let me go over here. So you said it's Instagram. That's what I said. If you send the mods, somebody drop the link to one of my mods in their IG, because then they can send it to me and I'll get right to it. But let me try right now to go to IG real quick and see what's T. Let me see here, y'all. Hold on. All right, y'all. So we are on the Shade Room. Now, Feel the Glow. You're going to have to get some play-by-play up in here. Now, you said it's on Boozy's. Hold on, y'all. You said it's on a post from Boozy. Let me see. Oh, Clarence Thomas. Whew. Let me see. I'm looking. Wait a minute, is this it? No, it's Halle Berry. Let me see, y'all. Feel the glow. Say something, baby. Or send that post to one of my mods so we can go straight to the link. Let me see here. Wait a minute. Oh, Lord, here we go. Help us, Jesus. All right. Shade Room says, one of R. Kelly's ex-girlfriends with a message. Well, okay. You know what? Okay. Here's what I'm finna do, y'all. Let me quit the share. Hold on. Okay. So remember. Okay. Let me be mindful of my words, because I don't want. I at least want the government to knock on my door. And by that, I mean, I don't want to say anything that they misinterpret and be like, So, okay. So what you say? The devil don't play fair, but God do. Okay. Well, you're right. God does play fair. So this thing ain't over. So let's see if she keeps that same energy. When the situation's different, right? Right? Yeah. Absolutely. All right. So I put the link in the chat for the IG. So now y'all can go straight to it. Now don't say Mel Cruz sent you, but at least y'all know where it is, so y'all can at least So, uh-oh. y'all know what to do. Comment on it or whatever, but don't abuse the lady, because they'll swear up and down that the only Mel Cruz was trying to incite a riot. Let me see. Feel the Glow said, until she posts a picture or video of herself, I'm sticking with Jocelyn Savage page being fake. Yeah, I don't know. It's just too much. Feel the Glow. It's so much. K Baby said, that's true. Kelz said he thanks us for staying strong for him. We got to stay strong for him because that helps him get through this. Absolutely. And we do know that, his support team has access to social media. So, we want his support team to be able to say, yeah, man, they still support you, so, perfect. Baby Shay. Okay. So Baby Shay got it on her IG. Right on. That's what I'm saying. Who is the artist on your background music? Love it. Thank you. The artist is, it's a remix, and it's DJ Chop a Lot. He's the one that be chopping them all up. So now who the artists are, I guess it's him. But he be mixing them up with the flavor. Living Life said, at Feel the Glow, I'm not sure if her page is fake or not. Mel doing her thing. I love this channel. Okay, baby, thank you for that, girl. Appreciate you. Appreciate the support. I'm gonna make sure that I'm subscribed to your channel, because until you said that in the comments, I didn't know you were a content creator. So I'm gonna make sure I'm supporting you as well. All right. Cancel all they fake Urses. Charlie Wilson was a has-been until Kelz resurrected him. Absolutely, Pink Eyes. That post proves that it wasn't her that sent that letter. Probably Hallie. Okay. They're doing too much. So who is going to post a message for her when her line is? That's what I'm saying. Because see, we know that God plays fair. We know this. And we also know that God will send us through trials and tribulations for the perfecting of our faith. And I ain't on here trying to preach, but I am speaking the truth. So we know this. And we also know God don't like ugly. And I think like DJ Tyson say, and he ain't too fond of cute. So come on now. Shout out to Queen Maud, beautiful. Tiff West. Thanks for pulling up, Tiff West. Let me see here. Yes, we love Tiff West in the house. Let's see. Well, for the most part, y'all, I'm just going to tell you right now that pretty much it's just a matter now of staying encouraged and staying focused, because this Illinois case ain't going to stop because our feelings are hurt, and that might be what they was hoping, that our feelings would be so hurt we would start disbelieving Kelz, and, he would lose all his support. But that ain't going to happen, because and the people that are against Kelz, they think it's just about him having sex with someone underage, when they need to be thinking from the perspective of this case was about Kelz having sex with someone who lied about their age upon them meeting him, and Kelz having sex with someone who remained with him and who took money. It's deeper than that. And it's also about the government not looking at the evidence in its totality. But I ain't gonna repeat all that, because I'm sure y'all be like, damn, Mel, you said that yesterday. So I'll wait a day before I say it again. But the bottom line is, it's a social injustice. The way this case was tried, the evidence that was used to convict Kelly. And so, no, we're not going to lay down and take it. And just the same like with that YouTube blogger, until K Baby said what she said. I mean, at this point, based on the evidence, I don't know. But, we got to side eye them. They got to show us They got to show us that they're about justice too. So everyone, when we exit, hit your R. Kelly playlist so we can at least give them some royalties. Absolutely, Tiffany, only because part of the judgment in him being found guilty yesterday is $100,000. That's a fine that Kelz is going to be responsible for. So yeah, let's stream his music. Let's get the royalties pumping, because even whether he has access to them or not, let's help him pay it. This whole situation is crazy. I lost the good mood. That this doesn't mean that we should give up on the hope that's still there. Absolutely. Yeah, we can't give up hope, y'all. We have to stay encouraged. We are stronger than ever. Pink Ice gone and speak. Absolutely. We got to stay encouraged, y'all, whatever way we can. His record streams are up 500% today. Absolutely. So let's help it. Let's get it up to 1,000% today. So for the most part, y'all, that's it. That is the podcast. So be sure to like, share, subscribe, Replay Gang, leave a comment. You know, I want to hear from you. And until next time, y'all, we will see ya when we see ya. Welcome to the Only Male Cruise Show, the podcast. I am the Only Male Cruise. Be sure to hit the like button, share, subscribe, Replay Gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work.